to the backbench business debate. It is the background implications of the High Court judgment on the John Downey. Nigel Dodds to move.
Thank you, Mr Deputy Speaker. And may I begin by moving this debate and to put on record our thanks and gratitude to the Backbench Business Committee for tabling this important subject for debate in the House this afternoon. And I want to also put on record the fact that this debate has been requested on the part of all the parties from Northern Ireland that are represented in this House, the SDLP, the Alliance Party and the Honourable Lady from North Down, and indeed representations were made to the Backbench Committee for this debate by those parties and the Honourable Lady and also the Honourable Member for Tewkesbury, the Chairman of the Select Committee. So this has cross-party support, and I think it is important that we do have the opportunity, in addition to the statement that was made by the Attorney-General on the 26th of February in this House, to actually debate at more length and in more detail the background to and the implications of the High Court judgment in the John Downey case. I think it would be right and proper, Mr Deputy Speaker, to begin by putting right at the forefront of this debate the names of the 4 soldiers who died in the Hyde Park bombing on the 20th of July 1982, and to pay tribute to the memory of Lieutenant Anthony Daly, Trooper Simon Tipper, Lance Corporal Geoffrey Young and Squadron Quartermaster Corporal Roy Bright, who died in that horrific IRA bombing on that day, one of the most notorious incidents of the entire IRA campaign, and one which touched very, very many people, and to this day is remembered by so many for the deaths of those soldiers, but also the deaths of the horses that occurred as well, and the terrible images that were shown on TV screens and in our newspapers. And obviously, at a time like this, we may debate, and we will come on in detail to debate all the issues surrounding the administrative scheme, the implications of the Downey judgment and the political fallout and all of that, but it is important to remember that at the heart of this particular case are families who have had visited upon them not only this terrible tragedy, but also the terrible iniquity of the fact that justice has been denied to them, and that has been very eloquently and movingly and emotionally put by the families' representatives, and we all feel for them today, and indeed their hurt and anguish is felt also by many, many other victims of terrorism in Northern Ireland and elsewhere across the United Kingdom, when they look at this judgment and they see the revelations regarding the administrative scheme for on the runs and the hurt that they already feel through the loss of their loved one is brought home to them all the more when they realise that there are people out there who not only negotiated what turned out to be a get-out-of-jail-free card scheme, but also that there were people in government prepared to implement such a scheme behind the backs of the public, behind the backs of Parliament, and indeed something that victims knew nothing about. Mr Deputy Speaker, on the 25th of February of this year, we had the judgment in the John Downey case revealed to us. The court had actually ruled the previous Friday, but the judgment wasn't made public until consideration was given, as I understand it, for the possibility of an appeal by the Attorney-General. The Attorney decided not to appeal the case, and that's something that perhaps when the Minister comes to respond, it would be useful to have an indication of the reasons why it was felt, in terms of the judgment, why no appeal was made in relation to the matter. In terms of the judgment, not only was it decided and the news that Downey would not be prosecuted and that the prosecution would be stayed, which was bad enough in terms of the individual case, but what came as a real bombshell to the public and to everybody concerned was the revelation of the administrative scheme in relation to on the runs. And as I've said, the fact of the matter is that this scheme was not the subject of any kind of parliamentary debate, discussion or scrutiny at any time over many, many years. It had no statutory or legal basis. There was no public awareness of the scheme, and I'll come on in more detail to some of the allegations that have been flying about people should have known about it, that there was enough information in the public domain, as if, and I will give way in a minute, as if it was good enough to say that in relation to a matter of such import and of such importance that we should have all been able to piece together the pieces of the jigsaw. Instead of in the normal processes, let's have a statement, let's have a debate, let's have a process by which we can properly give consideration to all these matters. I give way to the Honourable Lady.
I thank the honourable gentleman for giving way, and I thank him also for placing the people who are most important in this debate, those who were victims of this crime, at the centre of what he says. There were very specific allegations made against him and his current party leader in the book written by Jonathan Powell that claimed that they were fully aware of the OTR scheme and that they were happy for that scheme to go ahead, provided the blame for that was laid at the door of David Trimble. Would the member like to comment on the record on that specific allegation that was made and has been repeated throughout this discussion?
Yes, I'm very happy to take that on board, and I will deal with that in detail when I come to that part of my speech. But can I say this? I have listened to a lot of the commentary, and the only allegation that's out there about the Democratic Unionist Party is this one reference in one tiny section of one book. That's right. That's right. Interestingly enough, it was never mentioned in the memoirs of the Right Honourable Member, the member for Neath. That's right. But I'll come on to that today, because actually what that refers to is not the on-the-runs administrative scheme, but it actually dealt with the issue of whether or not the government was going to bring forward legislation. It came after the St Andrews talks, or it came after the talks at Leeds Castle. And it was very clear that what we were saying was the government intended to bring forward legislation. We make it very clear that that was a matter for the government, but they needed to be very clear that that was not something that we subscribed to or signed up to. We would be opposing it in the House of Commons, as we did. We'd be tabling amendments to it. But it did not relate to the administrative on-the-run scheme, which was done as a deal, a dirty deal, behind the backs of everybody concerned. And I will come on in more detail to that on that issue at the moment, in due course. I give way to the Honourable Lady.
I'm most grateful to thank you, Mr Deputy Speaker. I'm very grateful indeed to the Right Honourable Member for North Belfast taking another intervention so quickly. Would the Right Honourable Member just take the opportunity to confirm that the Downey judgment makes it perfectly clear that Mr Gerry Adams, President of Sinn Féin, requested an invisible process to deal with on-the-runs, and that is precisely what he got, a deal in secret.
Yes, I can confirm that. Absolutely, the Honourable Lady is absolutely right that Gerry Adams, and it's revealed in the court papers, said, and I quote, "It would be better if there was an invisible process for dealing with on-the-runs." And indeed, the day after this revelation was made, Jerry Kelly, who became, as it turns out, the postman,
a man of letters.
A man. Wow. He's described as many things in Northern Ireland, but most famously, of course, the Old Bailey bomber. This was the man who was given these letters by government officials and others. We're yet to hear the precise details, who then communicated the contents to the people concerned. And he, on television, on the Nolan show the next night after this matter was revealed, said that Unionists were kept in the dark because if they had known, there would have been a crisis. So from the words of Sinn Féin themselves, the admission that Unionists were kept in the dark, that there was an invisible process. And the attempts by some people now to say, well, everybody knew about it, simply doesn't wash. Indeed, the Honourable Lady from East Belfast, her own party colleague, and her party leader, who just happens to be the Minister of Justice in Northern Ireland, with responsibility for the administration of justice and policing, he has made it very clear that he knew nothing about it either. And again, we'll come on to that later. So none of that washes as far as issues about people knowing about this scheme. Mr. Deputy Speaker, there was considerable shock at the revelations, at the fact that justice had been denied, at the fact that what people saw as the rule of law being undermined, that the behind-the-scenes nature of the scheme. There is considerable anger still in the province about the way in which things have come out. Sinn Féin have alleged that this is some kind of synthetic anger, that this was all a crisis or an issue, which is something that people shouldn't be too concerned about, that there's no real issue here at all, that everybody knew there was an issue. That simply doesn't wash either, Mr. Deputy Speaker. The anger in the community, and indeed not just on the Unionist side, but across the board, is real and palpable in terms of people's feelings that justice has been denied, and the fact that this scheme has been characterised by years of deceit, and that it is effectively a scheme devoid of any kind of morality. We, for our part, have made it clear throughout that we opposed and continue to oppose any kind of amnesty. And indeed is the consensus, I think, across all sides of the House, that there should be no amnesty for past crimes and terrorism in Northern Ireland. And when we raise these issues of amnesty and continue to raise this amnesty, we don't do so in any kind of narrow legal sense. We're making it clear that there should be the proper pursuit and interrogation of suspects, questioning leading to prosecution where evidence is available. In other words, not only should we not have any kind of amnesty in law or passed by this House and passed into legislation, but neither should there be any kind of effective or de facto amnesty by the back door. For whilst it is said that this is not an amnesty, and I understand what has been said, the reality is that in the case of Downey, for him, in his circumstances, this amounted to, in fact, an amnesty for him. That's correct. That's the reality of it. Now, we know from the police and others that there are some 228 people who were presented or brought forward for consideration under the scheme. And again, when the Secretary of State comes to speak, I should be grateful if she could update the House precisely in terms of the numbers of people who are involved. Our understanding is that the scheme began in 2000-2001. By 2002, 174 letters had been issued. The scheme did come to a stop for a while. Legislation was then considered, which was brought forward in 2005. The legislation, of course, the bill for an amnesty for OTRs, ended up collapsing. It didn't go anywhere because of the strong opposition of so many. Sinn Féin, who were in favour of the legislation, of course, when they came under attack for the fact that this would also apply to members of the security forces and others, then decided that they wanted an approach which is based on an amnesty for terrorists and their people, but soldiers, police officers and others should have no such consideration, and that there should be simply a one-sided approach. And of course, on that basis, the legislative approach collapsed.
With the right honourable gentleman.
I will.
Thank you again, Mr. Deputy Speaker. Once again, I'm very grateful to the Right Honourable Member for giving way. Would the Right Honourable Member just care to confirm to the House when exactly the bill was withdrawn? I believe, in fact, it was in January 2006. Perhaps the Right Honourable Gentleman would like to look at the sequence of events where, in fact, the Prime Minister, then Tony Blair, 3 days after he has his Christmas lunch, writes a confidential letter to the President of Sinn Féin saying that, in fact, he would ensure that the administrative scheme was expedited to make sure that, in fact, any remaining OTR cases were dealt with before he left office, presumably within 6 months.
Well, I'm very grateful to the Honourable Lady for that, because there is no need for me to go through the next part of my speech, and she has outlined the sequence of events that happens immediately after the legislation is withdrawn, and she's absolutely correct in what she has said. The administrative scheme is ramped up. The police set up a special unit in order to deal with this and to look at all of the cases. When Madam Deputy Speaker, the government comes into office, the coalition government comes into office in 2010, the scheme is continued. And as we now know, 38 cases were considered in the period since 2010. As I say, 228 in total. As I understand it, 192 were issued. There are other statistics in relation to the numbers that were returned, people who were arrested, people who were investigated, and as I say, I'd be grateful if the Secretary of State could update us in terms of the precise details of that. Yes, I will.
I thank the right honourable gentleman for giving way. Was he as surprised as me in the Secretary of State's written statement earlier this week to find out that in order to be able to reconcile and know how many letters had been issued and how many cases had been processed, one of the sources of information is now actually Sinn Féin's own records on this matter? The government now have to consult Sinn Féin in order to find out how many letters were issued by government?
Yes, I was interested to read that, but in relation to this scheme, nothing surprises me anymore, quite frankly. And one of the advantages of the current array of investigations that are now underway and inquiries is that between them all, we will get to the bottom of all of the facts in this matter and uncover exactly what has been going on, and also hopefully get to a better place moving forward. I give way to the honourable gentleman.
Speaker, and I thank my right honourable friend for giving way. In practical terms, if someone's on the run and they're given an amnesty, the police will presumably take their names and their photographs off the wanted list. So what slightly surprises me, and I wonder whether you have a view on this, is the fact that people didn't realise amnesty had been granted for nearly 200 people, because presumably their photographs will be taken off wanted lists and their names.
Well, the honourable gentleman raises the issue of amnesty, and I've mentioned earlier that in terms of what this amounted to, the reality was, as was borne out in the Downey judgment, that if one had a letter of comfort issued by whoever it was, and again the inquiries no doubt will probe who actually gave authority, who actually signed off on these letters, to whom were they transmitted, and so on and so forth, that if one was in the possession of this such a letter, then one could use it in court as a shield to prosecution, even if evidence existed, if that information that you were being pursued or evidence existed had not been communicated to you. That's my understanding of the situation as far as Downey is concerned. And so effectively, because a mistake was made in relation to the facts in the Downey case, he was able to use the letter as a shield against any further prosecution. The prosecution was stayed. So for him, as I say, it was an amnesty, and given the fact that we have the rule of double jeopardy, he cannot now be prosecuted for this, for these particular crimes in relation to the Hyde Park bombings. But of course, it remains open in relation to other crimes, and I do hope that the prosecution authorities and the police are looking into those matters. Madam Deputy Speaker, as I say, we in this party, and indeed others, opposed any relief or amnesty or any kind of scheme which would allow on-the-runs to evade justice. That has been our consistent position for many, many years. We opposed the legislation when it came before this House in 2005. The recent suggestions by the Northern Ireland Attorney General John Larkin that there should be an amnesty as part of the Haas process, again was rejected by us and by others. Indeed, we as a party opposed the provisions of the Belfast Agreement in relation to the early release of prisoners, whereby people who had been convicted by due process, some of them convicted of the most heinous and horrible crimes of terrorism, on all sides, both sides of the community, were allowed to walk free from prison if they had served over 2 years in prison. And that was part of the Belfast Agreement. We opposed it. Other parties who opposed this scheme supported that. The point has been made, of course, and it's a fair point, that at least in the situation of the early release scheme, this was something that was known about. This was something that was out in the public domain. It was even described by the Right Honourable Gentleman, the member for Neath, as a terrible betrayal of victims, and he understands the hurt over it. But it was at least open and out there, and people did know about it when they came to vote in the referendum in 1998. Give way.
I thank my right honourable friend for giving way. On this issue, does he agree with me that the galling thing about the Downey case is that had it not come to light, the scheme that he's outlining and our rejection of it, and many people's rejection of it, would still be continuing to this very day? That's correct.
Yes, well, the honourable gentleman makes a very, very good point. You know, if it hadn't been for the revelations in the Downey case, then we would still be in the dark about all of this, and he's absolutely right. The point about the 2-year release scheme, obnoxious as it is, and it remains obnoxious, it's still the case that anyone convicted of a terrorist-related crime which took place prior to 1998 can still avail of these provisions. So if somebody is found now and there is evidence against them and an offence occurred prior to 1998 and it relates to terrorism in Northern Ireland, the most they can go to prison for is 2 years. So that remains something that it causes great offence in Northern Ireland. But as I say, at least it was out there in the public domain. It was debated in this House. It was debated publicly. And decisions were taken as a result of that. But in relation to this scheme, there was never that kind of transparency at all. And as the Honourable Member for East Londonderry has pointed out, we would still be in the dark if we hadn't had the Downey case. So, Madam Deputy Speaker, we need to find out how all of this happened, who knew, when they knew. We need to examine the legality of it. We also then need to make sure that another Downey case never happens, and that these kinds of letters have nil effect when it comes to the issue of being able to stay prosecutions. When details did emerge, and the Attorney-General made the statement in this House on the 26th of February, it appeared to many that that was going to be it. That as far as any further consideration of the matter, there was no indication in any of the statements that were made at the time. And indeed, ministers were on the radio at lunchtime on that day indicating, as far as they were concerned, that was the end of the matter. There was nothing more could be done. As the House will know, Madam Deputy Speaker, the First Minister of Northern Ireland, my party leader, Peter Robinson, made it very clear that had he known about this scheme and been made aware of it at the time when devolution was being negotiated, the restoration of devolution, we would not have been able to proceed with devolution on that basis. And therefore this was a matter of considerable concern, given the fact that policing and justice was now a devolved matter, given that it was now the responsibility and is now the responsibility of the Northern Ireland Assembly and the Northern Ireland Executive, given that we have a Minister of Justice responsible for these matters, and that the First Minister, the Justice Minister, and the parties in Northern Ireland, apart from Sinn Féin, were not aware of this scheme, that this was something that needed to be addressed urgently. He made it very clear that there had to be a judge-led inquiry, and I welcome the fact that that inquiry was announced by the Prime Minister on the 27th of February. I also welcome the fact that on that day the Secretary of State also issued a statement saying, and I quote, "We will take whatever steps are necessary to make clear, in a manner that will satisfy the courts, that any letters issued cannot be relied upon to avoid questioning or prosecution for offences where information or evidence is now or later becomes available. I welcome the fact that Lady Justice Hallett has now been appointed and her terms of reference are in the public domain, and the intent is that she should report by the end of May of this year. Now, some people were critical of the appointment of the judge-led inquiry in Northern Ireland. Some people were critical, of course, who had nothing to offer other than base political point scoring and hadn't contributed anything in terms of actually trying to get to the bottom of these matters. We were very keen that the inquiry that was set up should not be dragged out over a long period of time, as we have seen with so many inquiries in relation to Northern Ireland matters, or that it should lead to a whole panoply of lawyers trooping in and out, extending the process, and we would never get a final outcome for months, if not years. So I welcome the fact that this is going to be a short, sharp, judge-led inquiry, which will be able to examine the papers and deal with many of the issues. I also welcome the fact, Madam Deputy Speaker, that the Select Committee, the Northern Ireland Select Committee, under the chairmanship of the Honourable Gentleman, the Member for Tewkesbury, is also and has also taken steps to set up an inquiry. The Justice Committee in Northern Ireland, under the chairmanship of my friend Paul Given, the Assembly Member for Lagan Valley, has also initiated an inquiry and indeed had its first session on the 25th of March, at which the Permanent Secretary of the Department of Justice appeared. And indeed, interestingly enough, at that first session, he, who is a former official within the Northern Ireland office, he admitted knowledge of the secret OTR scheme whilst in that role, but didn't feel it necessary, apparently, to inform the Justice Minister when he became Permanent Secretary of the Department. So that begs questions as well, but that's a matter for the Justice Committee in Northern Ireland to pursue. I give way.
I thank the right honourable gentleman for giving way, but as he would know, as a former minister, of course, a civil servant is not at liberty to give information about a role that they played as a civil servant for one minister when a new government comes into place. And so, whilst it may seem bizarre and frustrating that that knowledge was available in the Department of Justice, it would have been thoroughly inappropriate and, in fact, illegal in terms of the Civil Service Code for him to have shared it with anyone.
Well, I understand that completely, and of course we're all aware of the rules in relation to disclosure in terms of previous ministers and all the rest of it. That's one of the reasons why the judge-led inquiry is so significant and important, because the judge can actually inquire into these papers and have before her the various documentation, even if it relates to previous administration. So, and again, I think this is important when in terms of the other inquiries, because we must get to the bottom of all of the facts and who knew what when. I give way to the honourable gentleman.
I thank the right honourable member for giving way. The point made by the honourable member for East Belfast reinforces the fact that this arrangement was in effect a secret. Civil servants are quite free to comment on issues that they have been involved in and the past governments dealt with and they were engaged in, when those are matters of public policy and where it's sensible for the understanding of the current minister that they would have the benefit of that background information. The very fact that the civil service felt so precious about this underscores that it was a secret arrangement.
Absolutely. Yes, the honourable gentleman has put it very, very well. It does beggar belief. Yes, documentations and papers relating to the civil servant questions, time in the Northern Ireland office would be that would not be made available to the current Minister for Justice, but it beggars belief that no reference in anywhere at all could be made by any official in respect of this scheme. And as the honourable members put it very well, it is because there was a preciousness about ensuring that the secrecy of this deal was maintained. In relation to the various reviews, Madam Deputy Speaker, and inquiries, can I say also I am glad to see that the police, the PSNI, are also reviewing the process that led to the issuing of these letters. A team of 16 detectives has now been assigned to the review. They will investigate the circumstances of each of those who received a letter, and that will also re-examine the original checks carried out by the specialist PSNI team that I referred to earlier. that led to the PPS being told that none of the individuals were wanted. And the police have made it clear that investigations into killings and other incidents may be reopened if mistakes or new evidence are uncovered. So, in relation to all of these inquiries and investigations that are now underway, it is important to note that they are complementary, that they will work together. Some of them will be concentrating on perhaps the more political aspects and the ramifications of this dirty deal. Some of them will be looking at the legal side of it and the documentation in the papers. Some of it, like the Justice Committee, no doubt will want to probe what was the status of this scheme post-devolution when policing and justice was actually devolved. The police will obviously be looking at it in terms of what I have just indicated. So all of these things are complementary, all of them are important, and all of them must get to the truth and must find a way forward which implements what the Secretary of State indicated in her statement in February after this was announced, which means that there can be no bar anymore on questioning, prosecution, investigation of cases, and they must be brought to court. Briefly, Madam Deputy Speaker, on the issue of how this whole issue was handled in terms of informing members of Parliament and the public, I made a point of order in this House on the 5th of March in which I said that the examination of the parliamentary record going back over a number of years indicates that there were occasions in which the House may have been misled by ministerial statements, whether oral or written. I know it's not the responsibility of current government ministers to speak for previous ministers, but I think it would be important to hear in this House, on the record, from those previous ministers as to whether or not they stand over some of the statements that they made in this House. Because when one reads them now, it is very, very clear that there was certainly an economy when it came to the truthfulness of what was being said. I refer, for instance, to the question that was asked on the 11th of October 2006 by Peter Robinson, in which he asked, was the Secretary of State, the then Right Honourable Member for Neath, the Secretary of State aware, although we welcome the earlier answer from the Minister of State that no legislation is to be brought before the House, will the Secretary of State reassure the House that no other procedure will be used to allow the on-the-run terrorists to return? The Secretary of State answered, there is no other procedure. There is no other procedure, is how he replied to that. The Honourable Lady for North Down subsequently asked a question in terms of what was in terms of the House, in which she asked on the 1st of March 2007 about measures that the government are considering to deal with on the runs other than further legislation or an amnesty. And the Right Honourable Member for Neath replied, none. None. I give way to the Honourable Lady.
Thank you, Madam Deputy Speaker. I'm most grateful to the Right Honourable Member for allowing me to intervene just at that particular point when he has quoted a written reply that was given to me by the then Secretary of State for Northern Ireland, Right Honourable Member for Neath. It is important to note, in fact, the date of that reply, which was at the beginning of March 2007. We know from the Downey judgment that the first meeting of Operation Rapid held within the PSNI was actually chaired by Norman Baxter on the 7th of February 2007. It is with considerable regret that, in fact, the Right Honourable Gentleman for Neath is not here today. However, could I just say, in his defence, that I know that he was attending the funeral quite properly of his colleague and dear friend, Tony Blair, and that I do know that he also has a family commitment today.
Point out to him, he has now been speaking for 35 minutes and there are 14 members who wish to speak in this debate, and I don't really think they would appreciate a time limit which may be necessary if the Honourable Gentleman goes on for too much longer. So perhaps he could. Thank you very much.
Given the gravity of this situation and obviously the need to ensure that these matters are properly aired, and I do want to give time to the honourable members to contribute, but the honourable lady has quite rightly pointed to the reasons for the absence of the right honourable gentleman, and also indeed the absence, we understand, of the Minister of State, who is again another commitment which we understand. But, and I'm glad to see that he has now returned, but he wasn't here for the start of the debate. We appreciate that. There are all sorts of allegations floating about in relation to everybody should have known about this. We have dealt with the Sinn Féin comments. We know about their claims about there needed to be invisibility, that it needed to be hidden in case there be a crisis. We've had references to the Eames-Bradley report. When one examines the Eames-Bradley report, it does not bear out the allegation that this scheme was known. We've seen allegations about the policing board, we're told, when one examines the record, and I won't go into the detail, Madam Deputy Speaker, but again, that is disproven. In relation to the I'll just make a bit of progress. In relation to the issue of the Powell book, I won't go into any more detail because I think I have dealt with that matter very, very clearly. This was not about the administrative scheme. It was about the legislation that was being brought forward, and it is completely wrong to allege that somehow the DUP were part of any kind of information sharing as far as this scheme is concerned. And indeed, I don't make any allegation that other politicians in Northern Ireland knew about this scheme either. I'll give way to the honourable lady.
I thank the right honourable gentleman for giving way. Would it also be the case to say this scheme was already in train at the point when those allegations were made? Right. So the scheme was already operating behind everyone's backs, and then it was almost being redressed by saying that in some way people had knowledge that they did not have.
Absolutely. Yes, the honourable lady is absolutely right, and I think the consensus that exists in relation to the approach by all the parties in Northern Ireland, generally speaking, and indeed many other commentators, bears out the fact that this was a matter withheld from not just the public but from the political classes in Northern Ireland and those who were dealing with negotiations at that time. Madam Deputy Speaker, I close by saying that there are issues about the authority for the continuation of this scheme after 2010 when these matters were devolved, and that will have to be looked at by the judicial inquiry. There are also grave implications in terms of carrying forward the so-called Haas process, although I don't think it should be called the Haas process anymore since Mr Haas has gone, not to return. But in terms of the talks about the past and about parades and flags, there's no doubt to have a situation where talks and discussions were continuing, negotiations were happening, and one party around the table were aware of this scheme for an effective amnesty for certain individuals. Not to have it revealed, not to know anything about it, was a grave betrayal of trust. And as far as those who would say, well, the answer to all of this is to throw everything up at the air at Stormont, get rid of devolution and get back to direct rule. Well, this scheme illustrates what happens when politicians in Northern Ireland don't have their hand on the tiller. And it's interesting that in terms of the issues that are out there, and I speak to some of our Unionist friends back home who urge people to tear down what has been built up, who say that as a result of this we should all get out of Stormont and bring the whole thing down. I say that when you look at the issue of the iniquitous, immoral and deceitful on-the-run scheme, when you look at the issue of the Parades Commission, and you look at the issue of the flying of the Union flag, what have they all got in common? It is that they are the product of direct rule. They are the product of a situation where Unionists, and I say this as a party political point now, where Unionists did not have influence or power in relation to that decision making. And it would be a travesty to suggest that the way to correct the ills of this scheme is to tear down devolution at Stormont. So, Madam Deputy Speaker, it is important that these inquiries all take their course. We will be eagerly awaiting their outcome. And let us put on record, as far as this party is concerned, that if these matters are not adequately and properly dealt with in the way in which the Secretary of State outlined them in her statement on the 27th of February, then we will have to return to this issue again. This is not something that is simply going to go away.
The question